We're lucky to have Professor Whitman with us to speak today. As some of you know, since 2000, he's published 3 wonderful and influential books on comparative legal history. The Harsh Justice in 2003, Origins of a Reasonable Doubt in 2008, and The Verdict of Battle in 2012, and I recommend them all. His work combines 2 special virtues, I think. First, an original mind. He sees what others have not seen. Second, a care for and fidelity to the relevant evidence. It's a sort of a combination of intellectual daring and scholarly caution. I'd like to claim that this combination is a result of the fact that he did his PhD here at the University of Chicago. He did, but I think it would be inconsistent with the second of these 2 scholarly virtues for me to make that claim. I can't explain it, in fact.
It was the old University of Chicago.
I think it's special with Jim Whitman, and I don't know where it comes from. Today he's going to speak to us on his current work on the virtue of mercy and the seemingly inapposite subject of our criminal law. Before having him start, I think I'd be remiss if I failed to thank Lumen Christi for bringing him to us, and also the American Constitution Society and the Thomas More Society for helping to sponsor today's event. The floor is yours.
What a wonderful introduction. Thank you. I mean, I'm sure it's undeserved, but to the extent it is, I do actually credit the University of Chicago. Thanks, Dick, and thanks to Lumen Christi as well. I'm a guest here of Lumen Christi, and for that reason, I'm going to focus on Catholic theology in particular. The Catholic theology that I wrote about in the second of the books that Dick kindly mentioned, The Origins of Reasonable Doubt. Those of you who are Catholics may know that Pope Francis has declared this the Jubilee year of mercy. Those of you who are Americans may know that we don't have a lot of mercy in the United States. And, I'm going to do my best to navigate between those 2 poles. I'll talk partly about that book and about my understanding of what the sources in particularly Augustinian theology for a merciful approach to justice are. But in fact, I'm going to begin by talking about the state of affairs in America, and in particular about an article of mine, which I guess I'm here to flog in part, which came out a week ago, called Presumption of Innocence or Presumption of Mercy. So I'll start by describing the argument I make in that article. You may find it controversial. I'm sure I won't say enough about it. Dick has asked me to speak for 20 minutes, and no scholar finds that enough time to describe a thesis, but I'll do my best. But I'll start with that and then talk a little more about how Augustinian theology can offer ways of thinking about justice that are, well, I think healthier than the ways of thinking about justice that we have in the United States now. So my claim in the new article should be obvious from the title, Presumption of Innocence or Presumption of Mercy. That article is an attack on the strong orientation toward the presumption of innocence that we have in the United States. I warned you it would be a controversial position. The fear that I express in the article is that we have found ourselves in the midst of a legal culture in which we imagine that the task, really the overwhelming and only task in establishing and maintaining a just criminal justice system, is protecting innocent persons from unjust conviction. I think that that's terribly misguided for a couple of reasons that I'll go into. I think it is fundamentally important to protect the guilty, and that the best way of protecting the guilty is through having legal mechanisms that are best described, that are present, although not described in these terms, present in European systems, but that are best described as having a presumption of mercy. So let me defend this proposition a little bit, talk about the contrast between American law and the inquisitorial tradition, as we say, and then go on to the theological questions. Why would I say that we're too oriented toward the presumption of innocence? Well, here I want to begin by making one controversial claim. Very few innocent people are accused. Now, I will say the American criminal justice system has many, many defects, and it is almost certainly the case that more innocents are convicted in the United States than are convicted in other systems. I could go into the details about that if you like. But even in the United States, only a very, very tiny proportion of accused persons are innocent. And we know as a result of the Innocence Project, of course, as a result of DNA testing, that persons have been unjustly convicted, and it's a horror when it happens. I'm certainly not here to tell you that we don't need a presumption of innocence, but it's also important to emphasize something about the work of the Innocence Project and about these discoveries. We know that there have been unjust convictions precisely because of the DNA technology. But it's important to emphasize that the DNA technology is now present, along with many other technologies. As a result of these advances, it is less and less frequently the case that there is serious factual doubt about what happened in major criminal cases. As in the case of the Boston Marathon bombers, we even have people filmed in the act all the time. It's important to emphasize that because our common law system has developed on the assumption that there is, first of all, that it is systematically, that what happened in a given case is systematically mysterious, and second of all, that we have to structure the law of evidence in such a way as to import even more mystery into the cases than would otherwise exist. We have a system which depends on systematically creating doubt. We have that system that depends on systematically creating doubt, or that system for systematically creating doubt, now let me say, is deeply integrated into our common law structure, the common law structure of the criminal trial, which is very different from the criminal law trial elsewhere. Let me say a little bit about that. Our criminal trials, as you may know, I don't know if you folks know the contrast, our criminal trials are bifurcated into the guilt phase and the sentencing phase. The basic understanding, I will tell you, by the way, that developed only in the 19th century, in the history of which we don't know. But our basic understanding is that the guilt phase focuses strictly on the question of whether the accused has committed the act with which the accused is charged. And in particular, in principle, questions of what we call character are excluded from consideration in the guilt phase. That was not the case as late as 1850. That's something that developed in the middle of the 19th century, and we don't know the history of how it developed. We've worked with the assumption that this form of trial had existed from the origins, but it didn't. At any rate, the notion that you want to exclude character evidence, as we call it, is of course also deeply integrated with our understanding of how criminal justice should protect the innocent. Our fear is that the admission of character evidence will prejudice the jury or the fact finder against the accused, and in particular prejudice them in ways that make it more likely that the innocent will be convicted. The European system works very well. Let me say a little more about American criminal trials, or I'm not coming to the European system. Our due process protections, which we hold very dear, are due process protections that apply in the guilt phase. Now, there's a lot going on with the sentencing phase these days. I should say the sentencing phase. In the sentencing phase, historically in the common law, it is possible to consider character. So in the classic common law of trial as it emerged by the end of the 19th century, we have a guilt phase focused on the act, and as we'll say in criminal law theory, a sentencing phase focused on the person. All this is under a lot of pressure now, but just imagine that as the ordinary form. Our due process protections in the US are protections that involve overwhelmingly the guilt phase. They're protections that protect, once again, accused persons against the dangers involved in being accused persons in criminal justice. They do not pertain in the same way to the sentencing phase. We have very, very few rights for convicted persons. By international standards, vanishingly few rights for convicted persons. Once persons are convicted, well, in describing the situation, if you read the rhetoric of sentencing courts, you'll see that American courts often invoke a social contractarian theory of justice. What they will say is that convicted persons, having violated the social contract, have forfeited their claim on the protection of the laws. The Supreme Court has developed a large jurisprudence on punishment, which is, let's just say, is in line with that attitude. It is very difficult for courts to intervene in the management of prisons in the United States, by contrast with what you see elsewhere in the world. I could go into the details. This is a law school after all, but my time is short. I'll just say protections for the guilty are very, very few. Very few in the United States. The fact that our protections are overwhelmingly, by the way, due process protections in the guilt phase, that is, due process protections at trial, is important as a critical matter for the American criminal justice in another way. Very few cases, after all, go to trial. Most things are resolved through plea bargain, so that the rights that we hold so dear actually are not rights that mean very much for most defendants in most cases. Okay. That is a system, as I describe it, strongly oriented toward the presumption of innocence. This orientation that we see in the criminal justice system toward the presumption of innocence, I put it to you, but I could spend more time in the article talking about it. I won't do it here. I put it to you, is deeply integrated into an American understanding of how America is politically ordered. But it would take some time to describe how that fits in precisely with our sense of what a democracy is, what a liberal order is. Just trust me, it does. Continental European systems are very, very different. And they're very different in ways I want to defend. They're very different, I want to say, in ways that shock American observers all the time. Tom and I were talking about this. There is no bifurcation into guilt phase and sentencing phase. There are some rules excluding bits and pieces of what we would call character evidence, but very, very few. Ordinarily, what happens at the beginning of a continental trial, well, the first thing that happens ordinarily is that the defendant speaks, which the defendant never does in an American trial. There's a lot to say about that. But the second thing that happens is that a kind of a social worker appears before the court and reads out basically a pre-sentencing report. This is to us utterly scandalous. We can't imagine how these questions of character can possibly be presented before the jurors, and there are jurors, and the judges. I could say more about the structure of the trial if you like. I won't do it here. To us, this is utterly scandalous and represents an obvious violation of norms of the presumption of innocence. At the same time, the various exclusionary rules that matter so much in the American system play essentially no role. Illegally obtained evidence is introduced all the time. Once again, we see this as a violation of, well, now I have to say something about it, a basic political order in which the background assumption is that the great fear is that the state might be out to get innocent people or anybody else, so we must prevent the state from succeeding at trial by excluding evidence. None of that exists in this world. None of that exists in this world. That doesn't mean, I want to emphasize, that there's no presumption of innocence, because I'm not here to preach against the presumption of innocence. There is certainly a presumption of innocence. It's just not like ours. And in fact, in many ways, continental observers regard American law as a system that systematically violates the presumption of innocence. I could say more about that. I mean, that particularly involves things like perp walks, which made the headlines in Europe as a result of the Dominique Strauss-Kahn arrest in New York in particular. But there is, of course, a meaningful presumption of innocence. It's just by no means operationalized in the way that we operationalize it. But the truth is, having said that, I think the sociological truth about the kind of trials we're talking about is that they're not oriented toward the danger that innocent persons might be convicted that I've been talking about. The basic working assumption in these trials is that the defendant is guilty. Now, I could spend a lot of time, that requires some defense, some defending that proposition. I'll just tell you it's true. The basic working assumption is that the defendant is guilty. It's important to understand that that assumption makes sense in their world, any world except ours, for one very important reason. In the American system, 95% of cases plead out. Now, why they plead out and what's going on is a story we could spend a lot of time talking about. One thing that's worth emphasizing, though, is that that class of 95% of the cases, of course, includes the cases in which the defendant is obviously guilty. It's very rarely the case that defendants who are obviously guilty would contest the charges against them. So that if you're an observer only of American trials, you very rarely see a trial in which the defendant is obviously guilty. But in the continental world, and historically in the common law world, in the continental world now, it is a fundamental principle that all serious offenses must be given a full dress trial, and that means you see trials with obviously guilty defendants all the time. And here I must, again, at the risk of offending people, I have to say most defendants are obviously guilty. Most of the time, it's not hard to know that it was the husband who beat the wife. Most of the time, it's not hard to figure out what happened. You can talk to cops about that. Right? You can't bring the notion of trial that you get from watching American TV shows or detective shows to what goes on in the system. It's just not like that. So the reality and the working assumption in these continental trials I'm describing is that the defendant is guilty. So do they do anything to maintain a humane criminal justice system? Yes, they do. They have what I call the presumption of mercy. And let's talk about that as a procedural concept and then as a quasi-constitutional concept. They don't have constitutional law of the kind that we do. The working assumption as I say, a sort of a pre-sentence report is given at the beginning of the trial. And in effect, if you spend time with the trials and talk with people, the whole thing has the look to an American eye of a sentencing hearing. The whole thing is just about sentencing. It's just about what we're going to do with this obviously guilty defendant. In discussing the question of what we are going to do with the obviously guilty defendant, the background assumption in the European system is that it is a very, very serious business to impose criminal punishment on someone, and we should hesitate before we do it. And there are many rules in the system that are intended to encourage hesitation before punishing. Much too grave a thing to do without asking yourself long and hard whether it's necessary. So there are many rules. There are presumptive limits on how much of a nominal sentence will be served. There is a presumption against imprisonment as the ordinary sanction. I could tell you more detail, and I do in the article. If you're interested, you can take a look. But the underlying idea is an idea that I want to tell you is very much absent in American trial. That is, boy, it's a big deal to punish somebody. So you better be sure you're doing the right thing when you do it. And I'll come to the theological reasons why you might take that view in a moment. Right? Beyond that, of course, especially under the European Convention on Human Rights, there are many quasi-constitutional protections for the rights of the guilty. Many, many. Much intervention in the management of prisons, much intervention in the management of the criminal justice system, a much stronger orientation toward rights for the guilty. Now, in an obviously hopeless way, in that article I preach for the virtues of that European approach. I haven't said how I should have begun by describing how bad the situation is in the U.S. I guess our criminal justice system, I'll just say, if you already know, you know, is spectacularly, scandalously harsh by the standards of the advanced economic world. One way of truthfully describing it is to say it's off the charts in the sense that you can't even show American incarceration rates on the same chart with the incarcerations of other countries. There's just no, visually you wouldn't be able to get any information out of it. My view is that the system is a disaster and that we should be more oriented toward a presumption of mercy, toward rights for the guilty. That's the view that I defend in that article, and I could say more about it. Let me now just move to the theological. In fact, it was the study of the Augustinian theology that led me to this in the first place. I'll talk about that a little bit. As I say, the presumption of mercy that I describe in the European system starts from the assumption that it is a very grave business to punish people. That's the strong assumption we see in the tradition of Augustinian theology. Now, I'll just say very briefly, my book, The Origins of Reasonable Doubt, is about that theology for the following reason. The beyond a reasonable doubt rule or standard, whatever you want to call it, is unintelligible. Judges in the common law world, as you may know, most states in the U.S. and the rest of the common law world, are not permitted to explain what it means to jurors, no matter how much the jurors beg. Right? People are convicted on the basis of something that we can't explain. How can this be the case? What I try to show in the book is that originally the reasonable doubt language, this business, was not a rule of law, it was a rule of moral theology. The background idea was not that you needed such a rule in order to protect possibly innocent defendants against conviction. What had to be protected was the salvation of judges who had to engage in the very grave business of punishing. St. Augustine talks about that in particular. Very, very interesting passages, by the way. I should have brought the book. Dick asked what the citations are, and I don't have them in my hand. But as a result, when St. Augustine talks about the theology of judging, he always talks about the theology of judging alongside the theology of war, because judges and soldiers, in his view, are doing exactly the same thing. They're killing people. And killing people is very dangerous to your salvation. Now, I can't go into all of the details of that. What emerged over the Middle Ages was a theology of what's called the safer way, which instructed jurors, and it's very complicated, believe me, but instructed judges and jurors too, without going into the jurors, that if they felt any kind of doubt, with a very high standard for doubt, the safer way for themselves, for the salvation of their souls, was not to convict. And this ran through the management of criminal justice all through the Middle Ages. 16th century things turned bad, but that's another story too. In ways that I try to trace in that book. Now, I'm sure you can see the connection with what I've been describing here. The underlying idea is, or to put it a little bit more strongly, in America we say, offer statements of the kind of the following form: we punish you, the defendant, without recognizing that in the course of punishing, things happen to us. That we can't, as it were, hold the punisher constant. It's not as though you don't do things that require serious moral reflection about your own place in the world when you punish. We simply assume that in a kind of a mechanical way, we punish as though the defendant had run into a brick wall which had no moral responsibility for what it was doing. That's not the Augustinian tradition. And let me say two more things about it, and then I don't want to talk for too long. Of course, the power of this Augustinian tradition depended on one critical fact, which is that defendants were ordinarily either executed or mutilated. These are blood punishments that were of concern. We don't mutilate people any longer, although we were doing it into the 1830s in the U.S., but that's, as you may know, it's there in the Fifth Amendment, punishments of life or limb, because it was taken for granted that you would be mutilating people in American courts. But at any rate, we don't do that, and we don't execute them very often either. One objection to any effort of the kind that I guess I'm making here to revive this sort of Augustinian theology is that the Augustinian theology depended on the idea that killing people is a very, very grave business, but we don't kill them any longer. Now, I think the right answer to that is the following. First, we do sometimes kill them, and one of the things you notice, by the way, if you look not at the theology, but at the natural tendency of the law to respond to these concerns, is that in death penalty litigation, we actually do have something of the attitude that St. Augustine described. And indeed, Rachel Barkow, who's wonderful, teaches at NYU Law School, has made some really admirable effort to suggest that what we ought to do in American criminal justice is import the practices of death penalty litigation into the rest of American criminal justice, which I think is right. But I don't think it's likely to happen. I just want to say, I want to add one thought about how it is we can understand, how we can bring this theological attitude back, and that's to recognize that although, for the most part, we don't kill people and we don't mutilate them, the things we do are nevertheless pretty grave and serious. It's no small thing to send a person to prison, even for 5 years, which in Europe, by the way, is regarded as a very long term. And in prisons that are really humanely managed, let alone for 25 years or life in horrific hellholes. Right? This is not a small thing to do to another human being. That's the attitude that Europeans bring to their presumption of mercy. They assume, as I began by saying, that it is no small thing to punish another human being, even though their punishment is far less harsh, spectacularly less harsh than ours. So, but in the end, in the US, I think if we want to revive this sort of attitude, that's what we have to understand. We are doing really extraordinarily grave, morally challenging things when we punish in the way we punish in the United States. And we ought to worry about our ethical, the states of our own souls when we punish. So I'll just stop there. That's an effort to bring a couple of writings together. So that's a great question. So what St. Augustine has to say about mercy, I'm not entirely sure if I know. Maybe Martha does. The strong orientation. So let me begin by describe my attitude and then theirs. I don't mean to deny that there are purposes of punishment that are also being served, and that we have some concern with the effect on the offender. All that is true. I will say that the great drive in the Christian tradition, very broadly, is toward a retributivist approach to punishment. I think in the current American state of affairs, that's a very dangerous approach to take to punishment. I am pretty firmly opposed to American retributivism, and I blame a lot of what's happened on the neo-retributivist revival. So I'm not going to invoke the Christian tradition on its theory of punishment. I think that we ought to have fundamentally an orientation toward incapacitation and dangerousness, which sounds sinister, but in fact produces a much more humane criminal justice system. But that's not this argument. As for the attitude toward mercy, I mean, I don't have a good answer to the question. In a sense, it's obviously fundamental because a lot of Christian theology involves the fund of grace that God has left to the church to administer. And it's clear that the church is administering the fund of grace, and the church does administer the fund of grace. My sense is that the right way to approach the question, I know I should have a better answer than this one, is to say that the question of the administration of grace actually still belongs a little bit more to the world of theology, moral theology, and a little bit less to the world of law. And I think that's probably right. Most merciful practice of law actually emanated from secular sovereigns and not so much from the church. Now that said, there obviously is within the canon law tradition and the practices of canon law judging lots of ways to go easy on people. And for the judge within the tradition to remind himself that he, like the person before him, is a sinner as well. I mean, there's a great deal. But I haven't worked through it, and my inclination is to say the retributive element is so strong that I kind of want to back away from that part of the tradition for American purposes. My diagnosis, which could be false, is that the egalitarian tradition doesn't seem to work very well. and that it's the hierarchical traditions that are more effective in criminal justice, partly because of the inescapable hierarchical character of what goes on in criminal adjudication. You just can't pretend that criminal adjudication takes place as between equals. Now, the egalitarian, this could be...
You got it in Woodson versus North Carolina, for example, the manifold frailties of human life.
Sure.
I mean, that's definitely...
And the American system doesn't look too merciful, despite whatever language you may find. I mean, the most dangerous versions of the egalitarian drive are, of course, the Kantian ones, and Kant was a great enemy of mercy in all kinds of ways. But it is the Kantian, this is why I mentioned social contract theory before, it is sometimes explicitly Kantian, sometimes implicitly Kantian, social contractarian notion of what in this Kantian tradition is called the right to be punished that frames our egalitarian discussions in the United States. I think that the discussions, I mean, how much theory of punishment can I give here in class? I don't know if you folks are familiar with this stuff. But there is a notion, which I alluded to very briefly before, this really is responsive, I promise. It's very strong in American justice, once again, that offenders have a right to be punished because punishing them means treating them as responsible signatories to the social contract or members of the social contractarian community or something like that. That's the way within the Kantian tradition in which we try to create an egalitarian criminal justice system. I think that that's been disastrous. I mean, it requires more discussion than we can have here. And my sense is that it's the sense of a comparatist and an anthropologist of a kind and not of a philosopher, is that when we look around the world, we see that there are more resources in hierarchical traditions than egalitarian traditions for producing a just criminal justice system. Or at the very minimum, that if we want to return to what we had circa 1960 or 1965, which was far more humane in the United States, we have to accept what the critics of that world regarded as its excessive paternalism, which is another way of talking about the hierarchical character of it. Basically, offenders are people who are not doing well in society and who need some serious intervention. Treating them as equals is a formula for mistreating them. That's not the, then I hold to that view very strongly, but I understand that I'm not going to persuade everybody when I say it, and also that it's very unlikely to have much traction in America. But this is how I see the world. So I have a lot to say in response to this. I was speaking in very general terms about Europe, but I do actually work on national traditions. And this article in particular focuses mostly on Germany and especially on Italy because it's largely about the Amanda Knox case. So I do go into quite a great bit of detail about the Italian system and the German system, and mostly I work on Germany and France with some Scandinavia. I was talking about Breivik yesterday. There are things to say about that one too. So I just agree. I mean, just for purposes of a short talk, it's useful for Americans to talk about Europe in a very general way. I didn't mean to say that this has Christian roots. What I tried to say and meant to say, since I was invited by Lumen Christi, is to say that if we're looking for some theological basis for trying to embrace this attitude, this is one place where we might look. But I didn't mean to say that it's Augustinian theology all the way down, or that that's what's created the systems. It is to some extent what's created the systems, but exactly how that happened is a very complicated story, part of which I tell in Origins of Reasonable Doubt. I also agree with your final point. That is, as a general matter, and this is just a way of expressing larger agreement with your claims, I disagree with people in comparative law who try to trace differences to their religious roots for exactly the reason that you give. There's a strong tendency in France in particular to say that what's best or most humane about American criminal justice has to do with the Catholic tradition. I agree with you, that doesn't make any sense. It's not just that the case of Italy looks very different, it's the case of Poland looks very different. And that Germany and Scandinavia are in some ways the prime examples of the sort of humane attitude that the French take. So I simply agree with that, but there's so I just agree. I should say, by the way, as long as I'm agreeing with you, that the French folks who say that will often describe the American system as Protestant. There are some ways in which that might be true, but for the same reasons I'm very skeptical about it. So. So that's another great question. So first of all, what you say is exactly right. I mean, as Kenneth Culp Davis said, discretion is always discrimination. The danger that this will be improperly used is always there, and we're never going to avoid it. Now, we can do all sorts of things to try to minimize the dangers, but the dangers are there. Point one. Second point, all criminal justice systems have to have some measure of discretion. for reasons that are pretty obvious. I mean, you just can't capture all of the possible conduct in the world in the criminal code. I mean, you're going to have to, it's got to be some play in the joints. And the person's always, there are always character issues that go beyond the act charge, no matter what. So that's all true. Now let me get to the comparison, though, because I think it's important. I wrote an article about this, too. The discretion is there in all of the systems. What strikingly happened, and this is something that critics of the American plea bargaining system often observe, is that let me say a little more about that. There's discretion is always there in the systems, but the criminal justice system, as we say, is a hydraulic system. That is, if you squeeze the discretion at one point, it shows up at some other point. Right? So that, to use the American example, if you introduce a system of determinate sentencing that eliminates all judicial discretion in sentencing, what happens is that the prosecutors start exercising more discretion. Not necessarily, by the way, in order to be nasty. It's sometimes that knowing that the defendant is going to face what the prosecutor regards as an inappropriate sentence down the line, the prosecutor will do something to let the defendant off. Same thing is true of cops on the beat. Right? They're hydraulic systems. Every time the discretion is exercised, there's a danger of discrimination. At the same time, you do need the discretion, so that's the problem here. When we contrast the American approach with the European approach, what we see very dramatically is that almost all American discretion comes before conviction, and after conviction, there's very little discretion. That's been the move with the determinate sentencing movement. In Europe, it's the reverse. In Europe, prosecutors have very little discretion compared to what they have in the United States, which is one of the reasons that plea bargaining doesn't present the dangers there that it does here. Whereas the Europeans leave lots of discretion after conviction. So that the really critical question is whether you want your discretion to come early in the system or late in the system. Now, for a variety of reasons, there are arguments you can make about that. Just coming to in various kinds, what I'll say in the American context is that what we've done in the American context, in effect, is to take the discretion out of the hands of judges and put it in the hands of prosecutors. If you think there's a danger in the exercise of discretion, you might well think that judges are present fewer of those dangers than prosecutors do. Judges, after all, just a matter of their formal role, are supposed to be more oriented toward justice without regard for persons, as we say classically. Whereas prosecutors are political agents in the U.S. and do all kinds of things, and they're running for office. So, but at any rate, I don't know if that seems to you an adequate answer. But basically, the drive in Europe is to eliminate as much discretion as possible until you've gotten a conviction, and then after the conviction to have very open-ended discretion. And I could describe it in much more institutional detail if you wanted. So, a big part of the determinate sentencing movement, again, all of this dates really to the mid-1970s and after, involves, among other things, what are called truth in sentencing laws, which on the federal level mandate that convicted persons serve 80% of their nominal sentence. And generally speaking, an effort on the state level, especially, to cut back on the possibility of parole. So there is less and less and less of it. And let me say a couple things about it. Yes, of course, that's a big part of the problem. We're not talking about formal rights when we talk about parole, exactly. We're talking about a system that will effectively result in some kind of a release.
Seems like mercy ought to play some part in that.
I think mercy ought to play some part in that. I entirely agree with you. I'll say something else has to play a part in it too, though. Part of the reason I think that Europeans can manage these non-carceral sanctions is that they have much more active social welfare states with a lot more personnel on the ground, right? There are people out there. So we've also cut back on the corps of probation officers and things like that in the U.S. We just have fewer trained people who can be out there supervising what's going on. So that's not just about mercy. That's about having a decently financed social welfare state. And that has to be brought into. But I entirely agree. I mean, the move, and I guess putting it in the terms that I've been using, I would associate it with the determinate sentencing movement and say that this is part of the effort to eliminate discretion after conviction. Yes, it treats them worse. So it treats them worse. There's much the same, in fact, exactly the same disproportion of minorities caught up in the criminal justice system over there. Just talking about Germany and France now. In France, you're not allowed to know, but you can find out, as there is in the United States roughly. And there are things that systematically orient the systems toward what are unquestionably discriminatory practices. I'll just give you one example. It came up yesterday when we did the other event. The question of whether there will be pretrial detention or not is determined partly on the basis of whether or not the accused person is well integrated into society. Guess who turns out not to be well integrated into society, right? So there's no question, and this comes back, yes, there's lots of discrimination in the systems. I would say two things about that. Again, it takes us away from the topic here. That's very important for one reason in thinking about American justice. It suggests a very important point. What's made American justice so harsh is not as such racism. Racism isn't the cause because they're demonstrably just as racist as we are. There are other things in the system that are magnifying the impact of the racism and making it more poisonous in the American case. I wrote about that in my book, Harsh Justice, if you're curious about it. But they're very, very racist. And again, I'm not here to tell you that there is a perfect nirvana of criminal justice in Dusseldorf. I mean, things go wrong in all of these systems. That the task is to try to find a way to make them go as little wrong as possible. But there's no question that minorities are strongly discriminated against, and it's going to get worse, is my prediction, and I have things to say about that. Things are very tense in Europe now. Yes, you can certainly see it happening. I do think it's probably not as bad a problem as we fear it is in the United States. But even to the extent it's a problem, it's worth emphasizing that even if you, as a Maghrebi Muslim, are convicted in France, you're still going to prison for what, when I wrote the Harsh Justice book, was an average of 8 months in very, very different circumstances. So that to that extent, at least the stakes are a little bit lower. You haven't gotten rid of the discrimination, but the harm you're dealing out is a little bit less egregious. So, but that may not seem a satisfactory answer, I understand. It depends how much discretion you've got, and I don't know the I don't know the details in the Illinois law. Well, of course, I'm preaching a somewhat utopian ideal here. This is not mostly recommendations for nuts and bolts changes. But I'll come to the racism question in a second, or the disparate impact, racial impact in a second. I'm a professor of comparative law, trying more to raise consciousness than to offer a blueprint for exactly how things can be changed tomorrow in American justice. And I'm actually not that optimistic that they can be changed. But I'm happy to try to encourage a different attitude if it does anything, and if your discretion permits you to do anything. I mean, with regard to the race question, let me say two things. I'll just repeat what I said before. It's really a different talk and a different subject. There is racism. It's a terrible problem. It's a horrific problem in the United States. It's horrific, and the impact on African American populations and on Latino populations is terrible in the United States. And I'm certainly not going to say there's no racism at all by any means. I just want to. I'm objecting as a social scientist to the proposition that that's what causes what's going on in the American system. It just can't be right because there's systems that don't look like that have the same purported cause. So some other thing has to be going on. Now, I think that has to do with the spirit of degradation that I talked about in Harsh Justice, but I can't talk about here. That is, we have, in a whole variety of ways, surrendered to a spirit of degradation, an idea that it's okay to treat convicted persons as subhuman. It is connected with what I'm talking about here. And that, as I say, tends to amplify the impact of race in a terrible, terrible way. But that's a complicated story to try to tell. The one thing I will say, though, about your affirmative action is the following. And it's, again, this is yesterday's talk and not today's, but my understanding of my argument about Europe is that they're strongly oriented toward equality as well. They've just tried to equalize things in such a way that the minorities get the majority punishment instead of saying the majorities should get the minority punishment. We faced a question, that is, they have leveled up, as I say. The strong historical tendency in Europe has been to give high status treatment to everybody, including in criminal punishment, whereas our strong tendency is to give low status treatment to everybody. And if you go back to the making of the sentencing guidelines, if you know anything about the history of it, you can see exactly the dynamic, right? The claim at the time by especially the liberals who supported the sentencing guidelines, and it was a correct claim, or it may have been a correct claim, it's still true, so it must have been correct then, was that white defendants were getting milder treatment than black defendants, basically, right? Now, that was true. If that's the case and you want to equalize things, you have two options. You can give everybody the white punishment, or you can give everybody the black punishment. What we have done over the last 30 years is to give everybody the black punishment. Now, that is a form of equality, but it's not the only possible form of equality. And I would rather have a system in which, we prosecuted everybody. That's by the way, the key question from the European point of view, coming back to your question, is in many ways not about the sentencing, but about the prosecutorial discretion. Because the rule in Germany is there's a tremendous risk of inegalitarian treatment if prosecutors can decide not to pursue cases. So prosecutors must be required to the extent possible to pursue everybody no matter what their social status. The sentencing practices aren't equal, but the idea there is that everybody of every description should face an equal risk of prosecution. That we don't have in the United States, and there again, the prosecutorial discretion is much more threatening from that point of view than judicial discretion would be. But yes, I would prefer a system in which everybody got charged and everybody got treated decently when they were convicted. I think that's a better system. And of course, that's what I'm here preaching for. We've done it much more broadly. You see it all through American law. Our privacy law is very similar by contrast with European privacy law, for example. And you see it in the norms of the social welfare state. So the European social welfare state is supposed to guarantee a standard of minimum standard of dignified existence for everybody, something we never conceived of in the United States. You're supposed to lift people up in dignity. So it's a much broader pattern than what you see just in criminal justice. That's a way of evading your question in a sense, because the question remains, why is the broader pattern there? And the short answer that I give, again, it's not really this talk, is that there is, it's going to seem very vague, but there's a strong cultural memory in Europe of a time when everybody, all of the majority population, belonged among the peasants, among the serfs who were treated like dirt, right? And a strong sense, therefore, that everybody ought to be treated respectfully now. That political sense that it's important to redistribute dignity, to bring everybody up, is much weaker in the United States. I think there again, if you talk about the African American population, people are much more deeply conscious of that sort of notion of that we were once treated like dirt, and now we ought to be brought up in status. But for most of the majority population in the US, that kind of argument doesn't really carry much weight, whereas in Europe it carries a lot of weight. Now, why we don't have that memory that we were all once on the bottom, well, that's, I mean, you know, but it's part in some ways of just American Civ 1. I mean, you know, this is what the US has been like from a very, very early date. Thought of ourselves as yeoman equals. I look like I'm not, that I'm being baffling when I say this. Again, it's kind of a different lecture. Well, I mean, in a sense, again, coming back to the American world of 1955 or something like that, right? The fear at that time was that judges were being turned into a variety of social worker or psychologist or something like that. And I think that's not an entirely inappropriate way of describing what was going on in the old penal modernist world. That is, we weren't thinking in terms of culpability. As David Garland says, he said, you know, the criminal justice system was one part of the social welfare state. It was dealing with particularly troubled clients who needed particularly serious interventions. But basically, it was dealing with, you know, maladjusted people who needed serious interventions. If that's your attitude toward judging, yes, you're going to assimilate the judge much more to the psychologist, social worker, something like that. So I think that would be the natural comparison. I mean, there are ways of thinking about forgiveness in the truth and reconciliation context that I think are a little bit different. I mean, in the sense that you can think of that, the proceedings there as involving less the kind of hierarchical mercy that I'm talking about and more community restorative justice or something like that, you know? And to that extent, if you're thinking that you're trying to heal the wounds within the community or something like that, I guess you are in a different universe from the universe that I'm talking about. I'm not sure that Martha Minow, that is, would be satisfied with that. But maybe that's a context in which you can talk about the more horizontal and less vertical mercy, now that you bring it up. You know, I guess if truth and reconciliation is supposed to work, in some sense it has to work in such a way that the winners are not treating themselves as the superiors over the losers or something like that. It's got to be reconciliation or something like that. Whereas I am defending a fairly hierarchical idea of how justice has to, a paternalistic idea, how justice has to work. So. Well, no, I think incarceration should be used for incapacitation. I mean, the criminal justice system can do lots of things. I'm sorry, but I'm interrupting you. So the question is what you use imprisonment for. We use imprisonment as the default punishment, and we regard it as an appropriate retributive punishment, right? So you did such and such a bad thing, so we're gonna compensate that, as it were, with 25 years or something like that, which I think is an unintelligible thought for a whole variety of reasons. This is about problems with retributivism. I don't think that that's the proper use of incarceration. I think there are many other alternative forms of punishment that are preferable for a whole variety of reasons, and we have to get into the details to talk about how they work and whether they work and so on and so forth. But I do think, having said that, I want to counter the idea that by preaching for mercy or a humane justice system, you are going to just throw violent offenders out onto the streets and let them prey on other people. That's not right. The criminal justice system has an obligation to keep people safe. But the way you keep people safe, at least if you're using incarceration, is to use incarceration as a form of incapacitation for seriously dangerous offenders. And I think dangerous violent offenders and not property offenders. I mean, property offenders don't go to prison in Europe anymore pretty much. So, sorry, in Germany and France and Scandinavia. And what follows from that is an attitude toward criminal justice, by the way, coming back to what I said before about retributivism, in which, the reality is you're going to focus much less on culpability, on the guilt question, and much more on the dangerousness question. Now, when we rejected the old penal modernism, the social welfare state model, the claim was that there's something, as I say, sinister or evil or nasty about talking about dangerousness. We should talk about desert instead. But I think all of our world of desert has produced a nightmare. I think as awful and sinister as it may sound to us to say we're going to see, in our paternalistic way, whether you are a dangerous guy, we're going to get an assessment. Actually, criminologists are very good at doing dangerousness assessments now. And we're not going to let you out into the street until we're, fairly confident that nothing bad's going to happen. That's what we really ought to be doing, as unsatisfying as it sounds, right? It sounds like you're not doing justice, but, I guess it's Lumen Christian Vitamin. In the last analysis, God's going to have to do the justice because we're just human beings. We're just trying to keep the streets safe. So.
Well, if there's nothing else, then no more questions. Let's thank
Thank you all so much.